India's labor laws are in the middle of their biggest transformation in decades. So, if you're an employer, an employee, or really just anyone interested in the future of work in India, you're going to want to pay close attention. In this explainer, we'll break down the key changes in the new labor codes that are set to affect pretty much everyone.
All right, here's our game plan. We'll kick things off with the big picture of this reform. Then we're going to zoom right in on the super important new definition of wages. After that, we'll tackle the major shifts in fixed-term work and gratuity, check out some new flexibility in Social Security, and then wrap it all up with the key takeaways for industry. So let's dive in.
First up, let's really get our heads around the massive scale of this reform. The main goal here? To take India's labor law framework from this incredibly complex, tangled mess to something much more simple and consolidated.
I mean, just imagine trying to navigate a web of 29 different central labor laws. Each one had its own rules, its own definitions. It was a compliance nightmare. For decades, that was the reality for businesses in India, and it made staying on the right side of the law a huge challenge.
And this is the solution. All those 29 laws have been boiled down into just 4 big codes: the Code on Wages, the Social Security Code, the Occupational Safety and Health, or OSH Code, and the Industrial Relations Code. The whole idea is to make things simpler, bring the laws into the 21st century, and ultimately give workers better protection.
Okay, but here's the million-dollar question, right? When does all this stuff actually start? Well, the answer is a little more complicated than just circling a date on the calendar.
So the codes have been passed and are officially set to be effective from November 21st, 2025. But here's the catch. The main parts of these codes can't really be enforced until the central and state governments finalize all the detailed rules that make them work. So we're kind of in this transition phase. And what's really important to know is that the big old laws like the EPF and ESI Acts will stay as they are until November 21st, 2026. That gives everyone a clear timeline for that specific changeover.
Now that we've got the timeline sorted, let's get into what is arguably one of the most important changes in these new codes, the new standardized definition of wages. This is a huge deal because it literally affects how almost everything is calculated.
This slide really says it all. We're moving from a confusing, fragmented system to a much simpler, unified one. You see, before, the amount used to calculate your provident fund could be totally different from the base used for your gratuity. The government wants to get rid of all that confusion and create one standard to rule them all. So, what exactly is this new definition? Well, at its core, wages now means just 3 things: your basic pay, dearness allowance, and any retaining allowance. Everything else, your bonus, house rent allowance, overtime, all of that stuff, is specifically excluded from this core definition. But it's not quite that simple. There's a really important rule that comes with these exclusions.
And here it is, the 50% rule. This is a critical test that every single company needs to wrap its head around because it has some major financial implications for how benefits are calculated.
Let's walk through a quick example. Say your total pay is 1 lakh rupees a month. Of that, 40,000 is your basic and DA, and the other 60,000 is made up of all those excluded allowances. Now, the rule says if those excluded parts make up more than 50% of your total pay, the extra amount gets added back into your wages. So here the allowances are 60%, which is 10% over the limit. That extra 10,000 rupees gets added to the 40,000 base. Your new calculable wage becomes 50,000. The bottom line? For employers, this is probably going to mean higher costs for things like Provident Fund and gratuity.
Moving on, the new codes are also shaking things up for fixed-term employment. And this is especially true when we talk about the retirement benefit of gratuity.
So first, what are we talking about? A fixed-term employee is just someone hired on a written contract for a specific amount of time. The codes make it very clear. They have to get the same wages, allowances, and benefits as a permanent employee doing a similar job, all calculated fairly on a pro rata basis. And this is a game changer. For permanent employees, you usually need 5 years of continuous service to be eligible for gratuity. But under the new Industrial Relations Code, a fixed-term employee gets it after just 1 year. This is a huge step for the financial security of a growing part of the workforce, and it's a significant new cost for companies that use a lot of project-based or short-term staff.
Next up, let's talk about some new flexibility that's been built into the Social Security Code. This is specifically about how companies get covered under big schemes like the Employee Provident Fund, or EPF, and ESI. The code now has a clear path for voluntary coverage. So, if a company isn't automatically required to be part of EPF or ESI, it can now choose to join.
The key is that both the employer and a majority of the employees have to agree, and then they can send in a formal application.
But what's really new and interesting here is the opt-out feature. If a company joined these schemes voluntarily, they can later apply to leave them, again, as long as the employer and the majority of employees agree. This gives everyone a level of flexibility and control over their Social Security that just didn't exist before.
So, we've covered some pretty massive changes. For our last section, let's boil all of this down into some practical next steps. What should businesses and HR leaders actually be doing right now? All right, so what should you be doing to get ready? First, you've got to review your compensation structures. See how they measure up against that 50% wage rule. Second, model the financial impact. What will these higher contributions and new gratuity costs actually mean for your bottom line? Third, it's probably a good time to reevaluate your whole strategy for using fixed-term contracts. And finally, stay alert. Keep a really close eye on government notifications for those final rules, because that's what will kick everything into high gear.
We hope this explainer has been helpful, but please remember, this is an educational overview. It is not a substitute for professional legal advice. For your specific situation, it's always best to consult with an expert. The new labor codes are a bold move to modernize India's workforce. The big question is, will they create a more fair and prosperous future for everyone? Only time will tell.